Hello and welcome everyone to PW Only IAS English channel for UPSC Civil Services Preparation, your one-stop solution for UPSC. Now in Udaan series for Prelims 2025, in today's lecture we are going to talk about fundamental rights as a topic, part 3 of the Indian Constitution, the justiciable part, the most important guarantee to the citizens of India when they wrote the Constitution for themselves, that in case their own government becomes tyrannical, their own government becomes against them, then what is the protection do they have in the Constitution of India? It is this part 3. So today we are going to talk about this interesting topic today in analytical manner so that you are able to comprehend the questions which are not just factual in nature. So let's get started without much ado. PDF can be downloaded from the Telegram channel which has been specifically created for my purpose. Jatin Verma sir, PW Only IAS English is the right correct full name of this channel. You can subscribe to this channel to stay updated about current affairs, economy, budget, everything under the sky with regard to current affairs. Insofar as UPSC is concerned, you will find a lot of content on that channel. My updates about video sessions, upcoming lectures, all that will be found there. Now coming here, ordinance etc., some doubts were there. So ordinance, what is ordinance? It is an executive power in the standalone manner, but it is the legislative power of the president. Somebody had asked a question, so I'm just answering this. Now what is a right? A moral or legal entitlement to have or do something. This is your right. When you are born to your parents, you have certain inherent rights: right to live, right to breathe, right to get food. When you are born in the state of India, you are entitled to certain rights. Some of them are constitutional rights because they are mentioned in the Constitution. Some of them are mentioned in the most important part of the Constitution called Part 3, especially when it comes to India. Those are fundamental rights. And some of them are mentioned not in the Constitution but borrow their legal sanctity, they derive their legal authority from the text, from the articles, from the provisions mentioned in the Constitution of India. Those are called legal rights, for which the Government of India has enacted certain law. For example, National Food Security Act. National Food Security Act, right? So this way, these type of acts are enacted by the parliament of the day. The government of BJP or Congress, through these years, 75, 76 years, they have passed various legislations enabling certain directive principles to become fundamental rights, to be given as fundamental rights. National Food Security Act, Right to Information Act, Mahatma Gandhi National Rural Employment Guarantee Act. Those are not fundamental rights, but those are legal rights. So difference between fundamental rights, legal rights and constitutional rights is captured in this simple looking pie diagram. First of all, the red circle, the deepest circle inside, is the fundamental right. These circles are so designed in the order of their protection from the legislative action. Okay, quickly we'll go through this topic. As you can see here, fundamental rights are greater in their amplitude than constitutional rights, and then legal rights are at last. Constitutional rights are better protected, more powerful in their amplitude when compared to the legal rights. So same is depicted in the circle here, that when it comes to amendment by the legislature or parliament, the innermost layer, like the earth's crust, is the most protected. Then the yellow layer here, these are constitutional rights in the middle. So they can be amended. Fundamental rights can also be amended, right? But some of them cannot be amended. Fundamental rights, some of the fundamental rights that can be amended for giving effect to certain directive principles that we are going to talk about in the subsequent part of our lecture today. Now, legal rights, since they are given in the green, so they can be easily amended by the parliament or the legislature of a state, provided which layer, whether the state legislature or the parliament enacted them in the first place. If there is some food scheme, some Amma canteen scheme or some other scheme enacted by the legislature of the Punjab or Tamil Nadu, that can be changed or amended by the Tamil Nadu government or Punjab government respectively. Okay, but if when it comes to amending the constitution or constitutional rights, only parliament can do that. If it comes to National Food Security Act, enacted in the first place in 2013 by the Parliament of India. So this can be enacted, this can be amended by the Parliament of India only, since this was enacted by the Parliament of India. Understood? When it comes to fundamental rights, they are the justiciable part. They are justiciable in nature. Or even the constitutional rights are also justiciable. Legal rights are also justiciable. But what is the difference then? Difference is, while analyzing the amendment, while diluting the right, while checking the dilution of the right, the judiciary, the Supreme Court and the higher courts, the high courts in India, they would check, they would see it through the prism of basic structure. Whether the bare minimum guarantees given to the citizens of the country or the persons living in country, India, whether they are being tampered with, well, while checking fundamental rights or constitutional rights. Okay, the threshold of tolerance or acceptability of amendment of the judiciary will be little lesser when it comes to accepting the amendment to the fundamental rights. Now, the threshold of accepting the amendment to the constitution will be a little higher than that for fundamental rights, and threshold for accepting the amendment to the legal rights that were passed with the simple majority of the parliament will be even higher. The tolerance level will be higher from the judicial side. Judiciary will uphold the legal amendments to the legal rights. For example, right to information was diluted. So that acceptance of that amendment is of a higher magnitude. Got it? This is the only difference. Now, for the violation of your fundamental rights, you can directly go to the highest bench of law, that is Supreme Court, under Article 32 or 226. Okay, for violation of your fundamental rights. Okay, and now for violation of your constitutional rights, also you can go to Supreme Court or the High Court under Article 226. Even for your legal rights, you can go to high courts. So for high court, the writ jurisdiction of the high court is higher than that of the Supreme Court. For high court, you can go for violation of your fundamental rights and for violation of your constitutional rights and even your legal rights. To high court you can go, but you can go to Supreme Court. You can approach the Supreme Court with the writ petition only in case of violation of your fundamental rights, because Supreme Court is the highest court of land. Under Article 32, you can approach the Supreme Court only when your fundamental rights are violated. When it comes to High Court, under Article 226, you can go to the High Court in case of violation of any of the rights. Fundamental rights, constitutional rights or legal rights. Done? So that is why in prelims or in objective types questions, it is said that the writ jurisdiction of the High Court is wider than the writ jurisdiction of the Supreme Court. Okay. Now here difference has been captured. It has been explained already. Just one line. Though the model has been taken from the American Constitution, but Indian Constitution does not go as far as the Parliament, insofar as the Parliament cannot take away all the fundamental rights. Okay, so fundamental rights in India, they act as a limitation not only upon the powers of the government, but also the powers of the legislature. Also, the amending power of the Parliament cannot be used to amend the fundamental rights in toto. There are certain fundamental rights that could be amended for implementing directive principles under Article 39B and C to give effect to affirmative action, land reforms, for equal distribution of wealth, etc., for zamindari reforms. Those are the exceptions. Okay, that we'll talk about under Article 31 as we proceed along the lecture, guys. So this is there. Now, fundamental rights are protected and guaranteed by the Constitution, and they cannot be taken away by an ordinary law enacted by the state legislature. Legal rights are protected by an ordinary law, but they can be altered or taken away by the legislature by changing that law. Simple. Okay. So I'm quickly taking you through all these slides so that the purpose of these lectures, Udaan series, is to help you revise all these things in a time-bound manner. For those of you who are eagerly waiting to study polity from me, There are certain batches in which I'm going to start taking polity lectures. For example, it is Titan batch starting from February 3, as I've been told by the team. Okay, under that I'm taking polity. So we'll go through the whole of the text word by word, line by line when it comes to those lectures, right? Now, these are the things, case law, BCCI, etc. We'll talk about these things at a later stage, guys. BCCI, whether BCCI is a body under the definition of the state, all those things will be discussed at a later stage, my dear students. Now, Article 12 defines the state for the purpose of Part 3. Why specific definition for the purpose of Part 3 is needed? It is said that in the beginning itself, Part 3, fundamental rights cannot be abridged, cannot be compromised with, or shall not be taken away by the state organizations, by the institutions of state. Now, that is why the very definition of the institution of state becomes important. Until and unless we define the institution of state, how can we say that the state bodies have violated the fundamental rights? Okay, so that is why in this part, unless the context otherwise requires, the state includes government and parliament of India, government and the legislature of each of the states, government and the legislature of each of the states, then all the local or other authorities within the territory of India or under the control of government of India, right? Now, just allow me a minute. Okay, so this is their case law, BCCI. The question had a case had arisen whether BCCI is a part of the state or not. So then the Supreme Court had answered that BCCI is very much a part of the institution of the state, right? The BCCI is not financially funded. Insofar as the BCCI is not financially funded, it does not come within the strict rigors of the meaning of the state as defined under Article 12. So that is why this matter was settled that BCCI, since it is not financially, functionally or administratively dominated by the government, so it will not be considered to be a body within the definition of the state. Am I clear? Okay, so these things are there. Now, the court therefore said that it does not come under the definition of the state. Zee Telefilms versus Union of India. This case I will explain a little later in the full-fledged lectures of mine on under the Titan batch or any other batch for Indian polity. Cooperative societies, the statutory regulation. Since the state regulates the bodies, mere statutory regulation like Cooperative Societies Act, does it mean that cooperative societies will come now under the definition of state? No. That way, state is regulating everything under the sky. Even the vehicles that are plying on Indian roads are also being, regulated. Number plate that is there, registration plate is there. So does it mean that they are also under the definition of state? No. See guys, defining the state is important because then only we would be able to regulate the activities of state, bodies, corporations, companies set up by the government insofar as violation of fundamental rights is to be prevented by the institutions of state. Now, this begs another question. Do these fundamental rights give us protection only against the tyranny of the state, persecution by state, victimization by police authorities, government authorities only? No, there are certain fundamental rights that protect us from the victimization by private individuals. Article 15 clause B. Okay, then bonded labor, Article 17 untouchability. So these type of acts, fundamental rights are there which protect us not only from the government or state bodies but also from non-state actors. But majority of the fundamental rights are a protection from the bad action or victimization by the government, I would say. Okay, so The test for determining as to whether a corporation can be said to be an instrumentality or agency of the government was laid down by the Supreme Court in International Airport Authorities case. In this case, the Supreme Court said if the entire share capital of the corporation, let's say National Thermal Power Corporation, okay, 100% shares are held by the government, or now it has been diluted if 51% of the shares are held by the government, or if the government is in a joint venture with, let's say, NTPC or ONGC plus Can India Limited. Can is the company of UK for oil exploration in KG, Krishna Godavari Drill 6, D6 basin. So if any private public collaboration is happening and if any fundamental rights are violated, then also government would be held liable. Okay, I'll give you examples. Like in Chhattisgarh, vasectomy, tubectomy operations were being conducted on women in Chhattisgarh, one of the tehsils of Chhattisgarh. Now, the government had tied up with an NGO to for female sterilization. You understand female sterilization? So as to control total fertility rate, some of the women were being operated upon by tying up with the NGO. NGO provided the doctors to the government so that per operation of tubectomy, 700 rupees will be provided to that NGO. This operation was conducted in filthy conditions, unhygienic conditions in a school, government school in Chhattisgarh, because of which, because of the poor hygiene conditions, the women got, they developed some symptoms, because of which 34 women died out of 150 that were operated upon. Now, government said that since the operation was conducted by NGO, NGO would be liable to pay compensation to those women who died. When the matter reached Chhattisgarh High Court, protecting the fundamental rights of those women and their relatives, their children, the kith and kin of those deceased, High Court said that people who got this operation done onto their bodies, they relied upon the government guarantee. Since it was sponsored by the government, the compensation would have to be paid by the state of Chhattisgarh, government of Chhattisgarh, irrespective of whether it was done by NGO, because when NGO was performing this function, it was acting as an instrumentality of state. So Article 12, the contours have been properly defined now. There is no scope as to whether it could be reduced. Any instrumentality of state, be it a joint venture, be it a collaboration, be it a public-private partnership entity, insofar as it is acting as an instrument in the hands of the state to carry out the public policy, will be considered to be within the ambit of Article 12. Any misaction, malaction, bad action by that instrumentality of the state would fall upon the concerned government, be it the government of state, the Parliament of India, Rajya Sabha, Lok Sabha. If some canteen people are hired in Lok Sabha and they die in the canteen of Lok Sabha because of poor upkeep and maintenance, it will be, compensation will have to be paid by the Parliament out of the consolidated fund of India. Got it? So this is how the country runs. This is why Article 12 becomes important. Now moving further, Article 13. Now, after understanding the definition of state, the meaning of state, understanding Article 13, which says that laws which are inconsistent with or laws which are in derogation of the fundamental rights, laws which supersede fundamental rights, triple talaq, they could be customary in nature, ancient ethos of Hinduism, Sabarimala temple, women are not allowed entry in the temples, in the precincts of the temple area, because the supreme deity, she is or he is a celibate. Okay, so these kind of things, triple talaq, dowry, these are customary laws. They come within the ambit of laws under Article 13. That means any such customary laws also should not be curtailing the fundamental rights of women, of downtrodden sections of society, whosoever. Even the two equal persons are there, one person's laws, one person's customary religious rights should not trample upon or should not compromise with the rights of another person. Done? Customary practices. Number two, laws enacted in the pre-British era. In the British era, pre-independence era, those laws also, insofar as they are inconsistent with the fundamental rights as mentioned in part 3, to that extent those laws would be considered as having been nullified. Three things we are discussing here: customary laws, pre-independence era laws, and post-independence era laws. All these three types of laws or provisions or customary religious practices, they have to conform to the part 3 of constitution, fundamental rights. They should not be against any of the fundamental rights. See here, let us say this is the moon or sun of the fundamental rights. It is being overshadowed by this part, let's say section 377, homosexuality, or dowry, practice of dowry, or temple entry ban. So in a way this is hampering the freedom of women, freedom of homosexual people to exercise their sexual orientation. It is in a way curtailing their freedom, right? When it comes to temple entry ban, Sabarimala, it is stopping the women from being treated equally. When men can go, why can't women? Why should boys have all the fun, as they say, right? On a lighter note. So what the point is, that is why whenever any such kind of law, British era law, section 377 IPC, CRPC, it used to criminalize any two gays, any two lesbians having sexual activity. Not anymore. Because the Supreme Court in Nas Foundation case, in various other foundation cases, in various other cases related to homosexuality, starting from 2010, then 2018, finally the judgment came. Supreme Court says that this section 377 is archaic, is not in sync with the times. Only type of morality that will prevail in the constitutional democracy is constitutional morality. These were the words of Supreme Court. Okay, so doctrine of eclipse derives its authority or is mentioned in the Constitution of India under Article 13 Clause 2. Article 13 Clause 1, 13 Clause 2, any law in force in the country should be in sync with the fundamental rights. To the extent that law is not in sync, doctrine of eclipse would be applied by the judiciary to nullify only that part of the law. Now see, same image is there, only to the extent that this image was overshadowed by this white color will be nullified, and rest of the law outside the scope of this black moon or sun, okay, will be allowed to exist. Tick marks as they signify. That will be held to be valid. Okay, this white part will be held to be valid. The only black part which is overshadowing the fundamental rights will be held to be invalid. Only this part will be held to be invalid. This part will be held to be valid. Complete law would not be declared as invalid. For example, Aadhaar Act violated the right to privacy. The matter came up before the Supreme Court. Right to privacy was not there in the Constitution. Supreme Court said right to privacy is a fundamental right as derived from Article 21, right to life and personal liberty of people of this country, not only citizens but to all the persons. Okay, so now having said that, Aadhaar, certain sections of Aadhaar like section 57, that Aadhaar could be made compulsory for anything you are doing. For booking even the railway ticket, government can make Aadhaar card, having the Aadhaar card mandatory. Supreme Court said no, section 57 is in violation. So only that section 57 will be declared to be invalid. Rest of the law, the white part of Aadhaar card, Aadhaar scheme, Aadhaar Act 2016 was held to be valid. I hope this point is clear to you. Moving to Article 14. Article 14 has got two connotations to it: equality before law and equal protection of laws. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Okay. Now, what is the meaning of equality before law? Equality before law means that nobody shall be given special treatment by virtue of his or her religion, race, economic status, etc. But is economic status mentioned here? No. That means if you are rich, you will get the VIP pass. You can have those privileges that come along with you being a rich person. Okay, but equality before law simply means that you cannot be given a special treatment because you are of a particular religion or you belong to a particular race or caste or sex or place of birth, right? And equal treatment of all the classes by the law. Okay, you can be seated in an economy class, on the economy class chair in the seat in the plane because you have economic capability to purchase that. But on these bases, any kind of discrimination would not be allowed. Equal protection of law, the doctrine of equal protection of law means that equal protection should be given by law in equal circumstances. Let's have an interesting case. You can see here, being human, some people are born ulta pulta, some people are born upside down, or they are born to do some wrong things only. That is why they are not called human beings. They are called being human. On a lighter note for Salman Khan, right? Now, his own driver in the black buck hunting case, he was the eyewitness that he deposed before. He appeared before the Rajasthan High Court and said that yes, he had seen in that green color gypsy that Salman Khan shot dead that black buck, an endangered species under Wildlife Protection Act, for which Salman Khan would go to jail. But after he said that, Salman Khan's bouncer or the might that Salman Khan had, all was deployed, everything was deployed to kill this person. Okay, do you think that these two are equal? One is being human and one is human being. I mean, this side human being, right? So, do you think that these two are equal? No. In the eyes of law, in the physical balance of law, if two individuals are not equal, they should be made to stand equal. Law will confer some extra privileges on the unprivileged. What was the privilege that was conferred upon him? If you appear before the High Court or any judicial bench and depose and become an eyewitness, but on the final hearing, on the next date of hearing, if you do not appear, you are declared as witness turned hostile. That is a criminal offense to mislead the court, for which there is a punishment for 3 years. This person, he absconded afterwards, after appearing only once. Later on, he did not appear, because of which Rajasthan High Court had issued arrest warrants against this person. But one fine day, he appeared before the NDTV camera person and said that I was escaping for my own life because I had got death calls, death threats to my life, that if in case I appear in the court, I would be killed. He was asked, do you have any proof to prove that you have been given the death threat? He said no. Still, Rajasthan High Court, applying the doctrine of equality before law, said that this person should be treated as speaking the truth. Why? Because applying the doctrine of equality before law in equal circumstances, equal protection of law in equal circumstances, the might that the other party has, it can be well imagined that yes, what he is saying is true. He must have gotten some threat to his life. That is why his crime of absconding or turning hostile in front of the court can be condoned, can be forgiven, right? So, no favoritism at all. Equality before law says that they both will be treated equal. But if we apply equal protection of laws, the law will tilt in favor of the driver in this case. Got it? Scalar equality is not preferable, is not present in the society. Since scalar equality is not present, it is because of the equal protection of law doctrine that we are able to give conferments like reservation, economically weaker section reservation, National Food Security Act, Antyodaya Anna Yojana, destitute of the destitutes, poorest of the poor will be given some extra privileges by the state. Got it? Poorest of the poor, richest of the richest. So that is why law, when seen from the equality before law concept as applied in the American Constitution, will not tilt in favor of the downtrodden section, in favor of the weaker section. But equal protection of laws in equal circumstances, if applied, will tilt the balance in favor of the poorer, relatively poor people. Done? Now, moving further, as a logical corollary, if circumstances are unequal, unequal treatment will be provided so as to create at least a feeling of equality, semblance of equality. So this doctrine is very important. If you've understood Article 14, see, 12 and 13 are basic. 14 is the one that guides 15, 16, 17, 18. 14, right to equality, is the crux behind Article 15, Article 16, Article 17, Article 18. Done? Now, examples of contemporary relevance: National Food Security Act, poorest of the poor, shifting of Tamil Nadu disproportionate assets case outside the state. Jayalalitha and Sasikala, they were influential. Jayalalitha ma'am has passed away, okay, long ago. So Sasikala, her AD, who was caught in corruption case, disproportionate assets case, she was getting extra privileges in whatever prison she was lodged in Tamil Nadu, in the state of Tamil Nadu, because she was the right hand of the chief minister, under whose tenure a lot of judges, IPS officers were appointed. So that is why she was getting a 5-star treatment. And the justice would not have been done if they would have kept in the same state where judges who are today the judges of the High Court of Tamil Nadu, they were district judges appointed by them. That is why her case was shifted outside. GST tax discrimination, lower tax on items of mass consumption. Okay, 0%, 5%, 0%. Common salt, openly available without any packaging, 0%. Salt, since everybody consumes it, 5%. Now then there is an Anil Kapoor wala salt which is promoted by Anil Kapoor, Tata Premium Salt, which is iodine, I mean what brand it is, 100 rupees per kg. On that 100 rupees per kg item, 12% tax will be charged. Okay, so items which are of luxury, which rich people can afford, they are charged at a higher tax, 28%. Toyota Fortuner, 28% tax. If you go for any ordinary car, 18% tax. So that is the difference, okay, because of EPL. Now, moving to the other things, these are all mains oriented things, guys. You can read it. The PPT will be provided on the Telegram channel. You can read these things, but these PPTs are being updated for the upcoming batch under the Titan series at PW OnlyIAS English. So these PPTs will still give you a sense of how am I going to teach polity, or how the polity is to be taught or understood for the purpose of UPSC Civil Services examination. All right. Now, sources, articles ensuring equal protection of laws in the Indian Constitution. The preamble to the Constitution of India secures to its citizens social, economic and political justice. Article 14 itself, Article 38 and 39. Just go through their text quickly by yourself. 39A directs the state to ensure the operation of the system promotes justice. Okay. The operation of the legal system, the operation of the economic system in the country, it distributes the opportunities in an equal manner. So legal assistance is provided. 39A talks about NALSA, National Legal Services Authority, has been created under Article 39A, right to free legal aid. Okay, so these are the directive principles. Now, again, this is Services Authority Act was passed by translating the essence of, or the diktat or mandate of Article 39A into a legislation, right? Now, coming to right to equality, as I said, Articles 14 to 18, all of them deal with various facets of right to equality in our country. Quickly, we'll deal with them. Article 14 we have studied already. Article 15 says the state shall not discriminate. So this guarantee, Article 15 clause 1, is available against the state. Against state. Okay, it shall not discriminate against any citizen on the grounds only of religion. Red, the alphabets in red or green, the words in red or green are so highlighted are so colored, so that's to enable you to focus on details which are relevant for prelims. Okay, on the grounds only of religion, race, caste, sex, place of birth. RRCSP. Memorize it this way. If a person belongs to religion, only on the basis of religion, that person cannot be discriminated against. Okay, if a person belongs to sex, a particular sex, female, if the females are known to show more careless when they are acting as nurses, functioning as nurses in the hospitals, certain positions could be reserved for efficiency of work for women. Likewise, if soldiers are known more for their valor or bravery in the combat role in army, certain frontline roles of army could be reserved only for male. Okay, so this is how, when only sex as a criteria becomes the ground for discrimination, that is not allowed. But when sex as a criteria combines with another criteria, administrative efficiency in army plus male sex, that these two combos are allowed. That is why the word only is written. Okay, place of birth. If you belong to a particular state, simply because you belong to Punjab does not mean that all the seats in the Punjab PCS would be reserved for you. Am I clear? But if Punjabi speaking is mandatory because of administrative efficiency, then you should have appeared in Punjabi literature or Punjabi as the language exam in matriculation. Got my point? So there has to be one more criteria so as to justify the discrimination. Discrimination only on these grounds as standalone grounds is not going to be permissible. Standalone, these grounds are not allowed. Simple. Okay. Now here, the state shall not discriminate against any citizen. Article 15, 16, 19, 29 and 30 are available only to the citizens of India, as we had seen in the lecture citizenship. Am I clear, sir? Are we done? Okay. Likewise, no citizen shall, on the grounds only of religion, race, caste, sex, place of birth, or any of them, be subjected to any disability. Now here, no citizen shall on the grounds of RRCSP be subjected to any disability, liability, restriction, or condition with regard to access to shops. Now here, what is this clause 2 saying? If I am the citizen, I should not be discriminated on the basis of my religion, race, caste, sex, place of birth. While I want to enter any shop, any McDonald, any temple, any masjid, any place of employment, if I want to appear in civil services exam, I should be. Okay, so this 15 clause 2 is the guarantee to every citizen against victimization or discrimination on these grounds vis-a-vis the state as well as the private individuals. Got it? Are you understanding my point? If there is a woman who as a citizen wants to enter a public place, a temple which is otherwise open to everyone, okay, and that facility should be wholly or part, see, access to shops, public restaurants. It does not mean the government restaurants. It means private restaurants, but which are open to public, for common public. That means a public restaurant, public toilet, Sulabh toilets are available to everyone. Now, they cannot say that this particular toilet is made for Brahmins. Brahmins will pay 5 rupees for every time they go for urination, and people who are not Brahmins will pay 2 rupees and they will go to the inferior toilet, urinal. Can that be done? No. If a place is otherwise open to public at large, it should be open to public at large. There should be no discrimination on the basis of religion, race, caste, sex, place of birth. So our constitution sought to do away with the evils of Indian society as they existed at the time of independence through the fundamental rights. So some of the fundamental rights are available to the citizens against the citizens themselves, against their brother citizens, sister citizens. brethren, as we call it. Got it? So this is how we need to understand these things. And 15 clause 2 subclause B says no citizen shall be subjected to any disability restriction with regard to the use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partly out of the state funds or dedicated to the use of general public. Okay, something that is open to general public should be open irrespective of any other thing, right? Nothing in this article shall prevent the state from making any special provisions for women and children. Now, these two are prohibitory in nature. State shall not, no citizen shall do any such kind of discrimination. Here, scope has been carved out for the state to do something positive for the women of the society because of the historical injustices meted out to women in the past. Sati, Johar, no right in the father's property, ancestral property to the women, domestic violence, like that. No education for them. That is why we are state under Article 15 Clause 3 is coming up with Beti Bachao Beti Padhao. Protection of women from sexual harassment at workplace. Vishaka guidelines. Okay. Pradhan Mantri Awas Yojana. The houses would be allotted in the name of women. Got it? So, Municipalities Act, the Local Bodies Act, 73rd and 74th Constitutional Amendment Act. 33% of the seats are to be reserved for women. These UPSC, no fee has to be paid by the female applicants. So these type of efforts have been made by the state to ameliorate through the affirmative action to uplift the condition. So these are allowed. Fourth, nothing in this clause or clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens for the scheduled castes and scheduled tribes. Okay, anything given over here should not prevent the state from making such positive actions, from taking such positive actions for scheduled castes and scheduled tribes. Okay, for any socially and educationally backward classes of citizens. That means if any section of citizens does not belong to SCs or STs but is otherwise socially and educationally backward, we are inadvertently talking about OBCs, but not only OBCs. Even if you are not an OBC, but you are economically belonging to economically weaker section, okay, and you can prove that you are educationally backward. If the states through the socio-economic caste census comes to a conclusion that a particular community is socially and educationally backward, that community could also be given benefits of reservation, irrespective of whether they are OBCs, SCs and STs. So Article 15 Clause 4 is this wide in its scope of reservation. Am I clear, guys? So this is Article 15. Now 15 Clause 5. Nothing in this article or in Article 19 Clause 1. Article 19 Clause 1 talks about freedom of speech and expression. Okay, Clause G basically talks about subclause G. It is this Article 19 Clause 1 subclause G. This talks about right to carry out any business or trade or profession. If I am running a coaching institute, for instance, if the state applies any reservation on the college that I am running, school that I am running, if the reservation provisions are made applicable to PW, state cannot be stopped merely because a person has got right to do business. Okay, if Article 15 says that there shall be, Article 15 Clause 1 says that state shall not make any discrimination. But Article 15 Clause 5 is saying that insofar as the upliftment of socially and educationally backward classes is concerned, even the private educational institutions are also within the ambit of reservation. This was done in This was brought about in the constitution so that now more and more institutions are privately run. Private educational institutions are also now under the ambit of reservation. Okay, so 19 clause 1 subclause G, article 30, even the minority educational institutions, okay, they are outside the scope of article 30 clause 1. Done. Now article affirmative action. So these articles, clauses 3, 4, 5, they deal with the affirmative action exceptions. Similarly, article 16, 17, 18, they are the other facets of right to equality. Okay, so let me show you a diagram here, a flow chart or circular diagram. Article 16, as we go deeper, article 14, since our constitution is the lengthiest constitution in the one of the lengthiest constitutions of the world, we have mentioned everything in quite a detailed manner. That is why people like me who teach polity get some work to teach you, right? Otherwise, had it been American constitution, jobless, because that constitution mentions only right to equality. Don't you think everything that we've just talked about in last 15 to 20 minutes is all nonsense? Why? Because our constitution, not nonsense in the sense that our constitutions did something wrong. It means that we are so detailed so that there is no ambiguity. Our constitution makers knew that we are weak in English, or we may not be able to comprehend these things, or the political class of the day might twist these things in the manner in which they want to implement so as to extract more votes. That is why they mentioned everything so succinctly, so beautifully, that we don't even have to bother about the interpretation. We don't even have to leave the interpretation of the constitution in the hands of some of the politicized judges. Getting my point? So that is why everything is mentioned. Article 14, if we go deeper, societal inequality has been taken care of. If we go further deep, discrimination in the matters of public employment has been dealt with. Right? If we go further, Article 17, untouchability. All the social evils that affected India during that time have been explicitly mentioned. That is what makes the fundamental rights topic, part 3, the chapter as given in D.D. Basu, M. Lakshmikant, so lengthy, because everything needs to be explained word by word. And that is the beauty of our constitution. That is why judges, no matter howsoever intelligent they are, honest they are, many details have already been taken care of. The only change that can come in the constitution or that is required is progressive. The basic details are already taken care of. That is where the constitution of India is so very beautiful. Got it? I mean, I was telling you in the lighter note that had it been American, if it were American constitution, these things would have just been mentioned under Article 14. Rest of it you can amplify, extrapolate, depending upon the needs of the time, depending upon section of society you're talking about. Done? Now, general understanding, Article 16. We'll talk about Article 16 onwards in the next class tomorrow. The basic understanding fundamental rights is what takes time. In another 10 lectures, 10, 12 lectures, entire polity for prelims 2022, 2025 under Udaan series will be taken care of in its entirety. Stay tuned for more lectures to come. Tomorrow, the whole of the fundamental rights will be taken care of. Thank you. Bye-bye, guys. Have a pleasant time ahead. Keep revising, keep studying, keep practicing the MCQs on the topics that we've already dealt with. PDF of this lecture will be shared on Telegram channel, the link of which is given in the description box in this video. Or I'll share some practice questions on the Telegram channel. My friends from South India, Northeastern India who can understand only English, we are taking a lot of new initiatives to help you streamline your preparation so that you have a one-stop solution in the form of this PW OnlyIAS English channel. In the coming days, you will see many more such initiatives, and I'm going to come up with the budget session also in the coming days. This budget session will take care of your this thing, entire budget analysis, budget at glance, complete detailed discussion on budget for prelims 2025. On that day, there may be no class for this thing, your polity regular class, because I'll be busy with studying budget and making the PPTs in a manner that you are able to understand. Stay tuned for more update on the budget session. See you in the next class tomorrow. Bye bye guys. Thank you.